Hello. Good morning, everyone. Welcome to the second day of the first ever Delhi Arbitration Weekend. It's a pleasure and honor to have been asked to compare the sessions for the day. And with the permission, if I can have the Honorable Chair and speakers on the dais, please. Round of applause, please. Thank you. We start the day with a very exciting topic, the great debate, confidentiality versus transparency in arbitration. Just to give a brief introduction of the topic, the debate between confidentiality and transparency in arbitration has long evoked strong opinions. While confidentiality is treated as the cornerstone of arbitration, lately it has been argued that transparency is required for arbitration in order for it to succeed as an efficient and reliable method of dispute resolution. The session would seek to address if confidentiality stumps all other considerations in arbitration, or the persistent calls for transparency are justified and possible without adversely affecting the popularity of arbitration. It is my absolute pleasure to introduce and welcome the chair of the session, Honorable Justice Hrishikesh Roy, Judge of the Supreme Court of India. Honorable Justice Roy was elevated to the Supreme Court in 2019, and prior to his elevation, he served as the 35th Chief Justice of the High Court of Kerala since 2018. Justice Roy was designated as a senior counsel in 2004 and was sworn in as a judge of the Guwahati High Court from 2006. Justice Roy has made notable contributions to the causes of alternative dispute resolution and legal aid. As the head of the Mediation Monitoring Committee at the Guwahati High Court, he oversaw the production of the film Shako, that is Bridge, which is still used as a training tool in mediation programs in India. He also spearheaded the training programs for judicial officers under the Guwahati High Court. One of his notable judgments came during the constitutional crisis in Arunachal Pradesh, when Justice Roy came down heavily on the governor's attempt to act in a partisan manner. We are thankful to have him gracing the dais. Thank you, sir. We welcome you. We also have on the dais with us today Honorable Dr. Justice Anita Sumanth, Judge, High Court of Madras. Dr. Sumanth has been the judge of the Madras High Court since 2016. Justice Sumanth was awarded PhD by the National Law School of India, University, Bangalore, in the subject of International Taxation, Electronic Commerce. Pursuant to being enrolled as advocate, Dr. Sumanth has joined the chambers of Senior Advocate Sri V. Ramachandran and thereafter practiced extensively before the Supreme Court, High Court, and the tribunals, as well as the Authority for Advanced Rulings, specializing in direct and indirect tax and corporate laws, and also held the position of Special Government Pleader, Madras High Court. Notably, she was also the chairperson of the All India Federation of Tax Practitioners, Southern Zone. We also are joined today on the panel on dais, Dr. Birendra Saraf, Advocate General, State of Maharashtra. Dr. Saraf is the current Advocate General of the State of Maharashtra since December 2022. Dr. Saraf has been practicing in the Bombay High Court for nearly 25 years and designated as Senior Advocate in February 2020. He was also conferred a PhD for his research on the subject Judicial Intervention in Arbitrations in India. Dr. Saraf practices in diverse subjects, including proceedings relating to town planning, writ petitions, and alternative dispute resolutions, including intellectual property and property laws. Over the years, he has appeared in a plenitude of cases of public importance, including complex issues of law. Dr. Saraf has also acted as an arbitrator, mediator, and conciliator, and has represented various PSUs and statutory bodies in several matters. We welcome you, sir. Last but certainly not the least, we are joined by the renowned Mr. Kevin Nash. Mr. Kevin Nash holds the position of Registrar of the Singapore International Arbitration Center since October 2021. Since joining SIAC in 2012, over the course of past decade, Kevin has overseen the administration of thousands of international cases under the versions of the SIAC rules and the UNCITRAL arbitration rules across a range of seats and governing laws. Under the SIAC Act 1994, Kevin is the statutory taxation authority, and he is empowered to authenticate and certify awards and arbitration agreements. Kevin is also qualified as a barrister and solicitor with the Law Society of Upper Canada and is a member of the Singapore delegation of the UNCITRAL Working Group 2. Lastly, Kevin is listed in Who's Who Legal as a global leader and national leader in international arbitration. We have an eminent panel of speakers, and without much further ado, I hand it over to the chair of the session to take it forward. Before that, just one small housekeeping request. We are reserving the questions for at the end of the discussion. Thank you. Over to you, sir.
Morning to all of you. This is, of course, a very important session, and I acknowledge the presence of Justice Vibhu Bakru, Pratibha, Rekha Palli, also Subramaniam Prasad and Shashank there, and all of you who must have traveled far to be in this venue. Now, the panelists that I am supposed to be associated with are very distinguished in their own rights. So they will be, we have designed that they will each sort of focus on a certain area, and then thereafter we'll also have a common discussion. But on the topic confidentiality versus transparency, I would first and foremost say that in almost every profession, whether it is law, journalism, finance, medicine, or academia, people rely on confidential communication to do their job. We count on the space of trust that confidentiality provides. Historically and traditionally, arbitrations are considered to be private in nature and not open to public, so that parties may resolve their disputes through a trusted mechanism without public exposure. Many consider confidentiality to be a key advantage to arbitration as a dispute resolution mechanism. The Indian statute, following the model law, did not cover the subject of confidentiality till recently, and for that matter, neither did the original UNCITRAL model. What does transparency means in the context of arbitration? Are all submissions, contracts, evidence laid in an investor-state dispute or any other arbitration to be made publicly available? Or is it only limited information which should be made available? Should third parties, for instance, a non-disputing parties, be entitled to file written submissions regarding matters within the scope of the dispute with the arbitral tribunal? If so, who are those third parties? Who should be allowed to do? Should hearings be public or private? And in balancing the need of parties, how is confidential information to be protected if no part of the proceedings are to be kept confidential? These are some of the key questions which arise for discussion in today's meet. Some of you would be aware, under English law, the general assumption is that commercial arbitrations are to be considered private and confidential. Disclosures can, however, be made when required by law or to protect one's interest. The general common law rule of implied confidentiality is thus subject to exceptions carved out from time to time on a case-to-case basis. Australia and Hong Kong are amongst the few jurisdictions to have codified their confidentiality regime. Both are made subject to disclosure inter alia to protect or pursue a legal right or interest. Australia, in particular, has an elaborate code defining arbitral proceedings. The Indian Act, as you know, does not attempt a definition. The Australian legislation also sets out the circumstances under which confidential information can be disclosed and circumstances under which the tribunal may either allow or prohibit disclosure. The statutory regime is subject to parties' contract to the contrary, and parties may opt out of confidentiality regime if they so wish. The United States, in contrast, does not require the parties or the arbitrators to maintain confidentiality and leave the parties to provide for confidentiality as they may wish. Many other jurisdictions, including Sweden and Norway, do not accept general implied duty of confidentiality. Arbitration institutes such as the ICC have in recent years moved from complete confidentiality to different levels of transparency. For example, publication of awards with names of the arbitrators and or parties is one of the recent provisions. Should we in India try to balance by opting for publication of redacted words to meet confidentiality expectations? Under the ICC rule in investment arbitrations, prospective arbitrators are encouraged to disclose all of their investment treaty cases in which they have acted as counsel, arbitrator, or expert. No doubt this has been introduced so that potential arbitrators leaning towards the state, a pro-state arbitrator, if I may just use the expression, or an investor, a pro-investor arbitrator can be examined before nomination. One interesting initiative taken by the ICC in the recently 2022 introduced Hold the Door Open policy, I think deserves mention here. Now this Hold the Door Open initiative, briefly, is a pilot project where, with parties' consent, 20 aspiring arbitration practitioners selected from 14 African countries, where either virtually or in person are given access to arbitration proceedings. The intention being to train future leaders in international arbitration around the globe. The observers selected for the purpose are, of course, required to maintain confidentiality. The confidentiality provisions was introduced in the Arbitration and Conciliation Act 1996, that's the Indian law, by the 2019 amendment by introducing Section 42A. Three things are noteworthy. The non-obstante clause, the confidentiality requirement, overrides all other laws for the time being in force, including, say, the RTI Act, that is Right to Information Act, which too creates an overriding obligation. Second, the absence of any exceptions other than where it is necessary to disclose award, and that too limited for the purpose of implementation and enhancement of the award. Thirdly, no sanction or consequences are prescribed for non-compliance. Deliberations on Section 42A and its legislative backdrop and its consequences will be presented today by Dr. Justice Anita Sumanth, who before her elevation had practiced extensively in the field of taxation law and corporate law. If I may use the expression, Justice Anita Sumanth is a scholar judge and has been awarded the PhD degree on the subject of International Taxation and Electronic Commerce by the National Law School of India, University, Bangalore, a premier law college of this country. In commercial arbitration, should the disclosure requirement include, for example, disclosure of appointments by state entities or having acted as counsel for state or state entities, particularly in the context of the group companies doctrine, since both the 5th schedule and the 7th schedule on relationship of arbitrator with parties or counsel include an explanation that the term affiliate encompasses all companies included in a group of companies, including the parent company. The parent, although not a company, every central PSU is the government of India acting through the President of India, or in the case of state PSU, the state government acting through the government or of the state. I do feel that it seems strange that a private interest of a party to keep arbitration confidential could prevail over public interest to assist with an investigation, let us say for a criminal case, and that too not concerning any document produced by the party who claims confidentiality. What measures of transparency should be resorted to while protecting confidentiality to the extent necessary to preserve the interest of parties opting for arbitration is a question for debate, and on which I am sure our esteemed speakers today would have much light to throw. On the practical difficulties of implementation of the confidentiality provisions under the arbitration regime in India, I'll request Dr. Birendra Saraf, the Advocate General of the state of Maharashtra, to enlighten us and also to provide us with few concrete examples where dichotomy between confidentiality and transparency is visible. I would particularly request Dr. Saraf to discuss the implication of non-adherence to the principles of confidentiality and its implication in a challenge to annulment of awards. The Singapore International Arbitration Center, SIAC, has earned a very good name as being a forum of convenience and of choice for conducting arbitration. In my eyes, Dr. Kevin Nash, as the Registrar of SIAC, has rich experience of overseeing hundreds of international cases, both under the SIAC rules and the UNCITRAL arbitration rules. Being in the League of International Commercial Arbitration and Investor State Dispute Settlement, I would request Mr. Nash to give us an insight into the confidentiality regime that prevail under the SIAC rules. He may also provide some practical examples of conflict between transparency and confidentiality. As a man traveling from Singapore, Mr. Nash may also provide us some insight into the expectations of the foreign parties on their concern regarding confidentiality of their arbitral proceedings and the arbitral awards when they are conducted in India and when they choose India as a seat of arbitration. Since we in India are trying to catch up with the successful models in the other jurisdiction, Kevin may also give us an understanding on the factors that have contributed to Singapore's success as an arbitration choice destination. I would particularly request him to tell us about the course corrections that the SIAC had to make to meet the expectations of the parties, particularly on the issue of transparency and confidentiality. To begin with, I would request each of the speakers to give their introductory remarks for about 10 to 12 minutes. Panel may then respond to each other's perspective, and at the end of that session, we'd like to have a question and answer thrown open for the audience. Thank you.
Good morning, everyone. As an arbitration practitioner, if it's okay, and with your indulgence, I will sit rather than stand because that is the tradition. And I will also start perhaps with two propositions because it is Saturday morning and I do think that we need to be provocative. The first is, how much different would we treat confidentiality if instead of calling things confidential, we called them secret? So we don't have confidential arbitrations, we have secret arbitrations. And the next proposition is, what is the mandate of an institution? What is an institution supposed to do? Are we supposed to develop the jurisprudence? The Chief Justice of Singapore said very well that institutions have moved from mere stewards to the true thought leaders in arbitration. So do we have a mandate to push for greater transparency? So those are the two propositions that I will start with, but now I'm going to move on to a story, and that is the story of Singapore and how Singapore has developed into a leading destination for arbitration, and perhaps the similarities for India, New Delhi, and the Dubai International Arbitration Center in particular. Because there is a recipe for developing a destination for arbitration. You need the requisite hardware and software, and I see that hardware and software in Delhi and with the Delhi International Arbitration Center. At the inaugural session, I was actually quite stunned to see, because I should know, of how many cases are being administered by the Delhi International Arbitration Center in such a short amount of time. I think the amendments to the Indian Arbitration and Conciliation Act in 2015 and 2019 have really moved things forward. And that's similar to the Singapore experience of how the legislation and the institutional rules developed. So we see this with emergency arbitration under the SIAC rules introduced in 2010. Singapore followed by making or providing for the enforceability of emergency arbitrator orders. We actually took a very early step on, on transparency in the 2013 rules, and recently the Singapore legislation has been updated to provide that a tribunal can sanction breaches of confidentiality. So once you have modern, best-in-class legislation and you have effective institutions, what else do you need? Of course, you need an arbitration bar of experienced arbitration practitioners, and India has that in spades. You also need a geographic location. Where are you located in the world? One thing that I hear from my Indian colleagues very often is that India is the one place in the world where you can have teleconferences with Japan and the United States at the same time. It is very strategically located. If you look at some of the developments in MENA, the connection between MENA and India, India and Singapore, and overall in the ASEAN, India is exactly where you want to be for arbitration. And one of the most empowering and compelling things that I've seen in Indian arbitration is the change from Indian litigants perhaps being on the respondent side of an arbitration to now moving arbitrations. Indian parties increasingly are deciding where the dispute resolution choices are going to be. So it's not a case of the other side in a transaction saying that we're going to go to Europe, we're going to have the arbitration there. Now Indian parties are dictating the dispute resolution clause. And we've seen that at SIAC as well, certainly in terms of the seats of arbitration. So it is now a very common feature of an SIAC arbitration involving Indian parties. You would have an SIAC-administered arbitration, India law governing, and the seat of arbitration in India, maybe with counsel from India on both sides, all three members of the tribunal, Indian arbitrators. And for us, because we've almost grown from strength to strength with India, India is our most frequent foreign user. I look at how SIAC is actually composed. I can see 2 members of the SIAC Court of Arbitration in the audience today. We have 4 Indian members of the SIAC Court of Arbitration. In my team, I have soon to be 3 Indian qualified counsel on the board of directors, SIAC panel of arbitrators. So you really see this Indian fusion, this connection between Singapore and India. And I think that's why I'm so excited for the Delhi International Arbitration Center, because we have charted this path and now we see DIAC on the same path. So let's talk about confidentiality and how it operated for SIAC. To a certain degree, I think that SIAC was almost somewhat ahead of its time. So we are now in the 6th edition of the SIAC rules, the SIAC rules 2016. We are releasing a new set of rules. So in 2013, and sir, to your point about perhaps offering a course correction, we went a little bit too soon with transparency. So in the SIAC rules 2013, we said that we could publish anonymized versions of the awards. So that was in the SIAC rules 2013. I would say within 3 hours of the publication of the SIAC rules 2013, I had received about 120 emails where parties were saying, we cannot have this in the SIAC rules. Our arbitration is confidential. The ethos in the Asia Pacific is we care about the confidentiality of the proceedings. So in terms of a course correction, we very quickly followed in the SIAC practice note in 2014 that said SIAC will consult with the parties on the publication of the award. Now, what do you think might happen when you consult with the parties in the throes of a heated arbitration on whether they want to publish the award? It is very difficult to solicit party agreement on publication. And that is an important point on confidentiality versus transparency, because oftentimes I think that we as arbitration practitioners, for the benefit of arbitral jurisprudence, we want someone else's case perhaps to be published and anonymized. We actually had an edition of redacted awards published in 2012. I had the pleasure of redacting those awards. And the question is, how much can you redact an award to make sure that the parties are not identifiable? So typically, arbitration-related court cases in Singapore would be anonymized. So all of us in Singapore have had to learn many acronyms, so we can quite quickly quote 3-letter acronyms for these cases. But even if court decisions are anonymized or awards are redacted, the arbitration community can often determine the entities involved, particularly if it's a case of consequence. So the question is, how much do you have to redact it in order to make it properly anonymous but still usable? So starting from that, so we know that we want these published awards, but we also want to protect the confidentiality. And going back to the confidentiality versus secret distinction, Is this something that we want for our cases, for all cases, or for someone else's cases? So we know in 2014 we consulted with the parties and we found it very difficult to solicit agreement. This then followed with the SIAC rules 2016, where we said that we would publish redacted versions of awards with consent of the parties. Same principle. So at the SIAC symposium in 2022, I teased the new provisions on confidentiality and transparency in the upcoming set of rules, and I actually took a straw poll in the audience to determine, is this something that we really want? And it seems that the majority of users do want arbitral awards to be published, and I can see very good reasons for that. It's a question of construction on how you're going to do it. I think that then the crowd, and certainly with the practitioners that I've discussed with, we want these provisions to be prospective. So we don't want a clause from 2015 that then lands in an SIAC arbitration in 2013, where SIAC is going to be able to retrospectively publish an anonymized decision. So we're going to make it prospective, and then we're going to make it opt-out. So in practice, and the way that we're modeling this in the SIAC laboratory is that we will have these provisions. Upon the commencement of an arbitration, we will ask either party to raise their hand on whether they want to opt out of the potential publication of the award. We will then, likely at 91 days outside the period for setting aside, we will ask the parties again, does anyone want to opt out of the publication of this award? And then we are likely going to wait for a period of a year or perhaps 2 years before we eventually publish that. At that same conference, I was also saying, recognizing the importance of publication and transparency and figuring out how to balance it with confidentiality. We are looking in consultation with Darius and Tejas and the members of the SIAC Court of Arbitration, could we move to the publication of procedural decisions decided by SIAC, because these are actually quite usable for practitioners. SIAC does not get too many challenges to arbitrators, but when we do, we provide reasoned decisions. And these reasoned decisions might span 40 or 50 pages and drafted by the members of the SIAC Court of Arbitration. So we're looking at potentially anonymizing those. Same things, for instance, with prima facie decisions on jurisdictional objections by the SIAC Court, consolidation, joinder. These are all things that would be effective for the users that we are going to do in the intervening time. Now, if we switch from commercial arbitration to investment arbitration, that's where the considerations start to become quite a bit different. There are public policy reasons why you might want to have these transparent awards. And you can see the distinction in the SIAC rules 2016 versus the SIAC investment arbitration rules. So as many of you, as many of you might know, we were the first private commercial institution to publish specialized rules on investment arbitration. But even then, we tried to strike that balance between confidentiality and transparency, and we refer to it as a very commercial approach in investment arbitration. So there's certain matters related to the dispute that we will publish, and we can publish these sua sponte, and then for more detailed information, we would seek the consent of the parties, so the parties could agree to publication. And that raises an important point on the drafting of arbitration clauses, because if you think about it, and as was discussed at the outset, is that many jurisdictions do not have provisions on confidentiality. It's not in the legislation. So you will see, as a matter of practice, the parties may customize their arbitration agreement to provide for confidentiality. So the SIAC rules actually do have quite robust provisions on confidentiality, but if the parties want to derogate from those provisions, or if they want to strengthen those provisions, this is something that they can do. And it depends on the circumstances of a transaction or a dispute. In terms of practical examples, I have seen requests from parties where they have wanted an award in a case that is so consequential and sensitive that they wanted ethical walls within the institution on the confidentiality of this matter. So the parties have agreed that only the registrar and the relevant counsel at SIAC are to have sight of this case. We certainly see cases as well where parties want or more broad provisions on confidentiality, and that's something that we can give effect to. Ultimately, arbitration is a party-driven process, so if you don't have the benefit of those provisions in the institutional rules, you can customize bespoke clauses. And I guess to round things back and to go back to my initial proposition on whether arbitration, confidentiality, or secret, whether that nomenclature changes things, is confidentiality a fundamental tenet of arbitration? I think it does change things when you call it secret. It is the same mechanism, but I think that if we really want to support arbitration and knowing how the changes that are happening in dispute resolution and how crowded this dispute resolution marketplace is, I do think that arbitration and SIAC needs to move to greater transparency, while at the same time giving effect to some confidentiality on matters such as trade secrets and allowing parties to customize their clauses. So that is a quick view from SIAC and Singapore, but I look forward to the discussion on this thorny juxtaposition between confidentiality and transparency. Sir?
Good morning to all of you. After that very practical exposition of the subject from Kevin, I'm going to go to the other end of the spectrum and make a very academic presentation. My mandate before all of you is on two aspects of the matter. The first will be to set in some legislative context the provisions that we have today, touching upon the subject of confidentiality and transparency. And the second will be to touch on the interplay between public and private interests when it comes to these two facets. Now, arbitration has always been regarded as an alternate dispute resolution mechanism and a very private one, or a secret one, as Kevin said. Now, one of the sacrosanct features of the process has been confidentiality, and thus party autonomy would stand at its very heart and soul. In fact, at the inaugural session, both the keynote speaker as well as the Honorable Chief Justice of India had specifically referred to party autonomy as being a critical feature in the arbitration process, very integral to the process itself. Confidentiality will refer to the obligation of parties not to disclose information in relation to any aspect of the arbitration. I find that the notion of confidentiality overlaps sometimes with the concept of privacy also, as we know it. And transparency is contrasted with and pitted against the obligation of confidentiality. There was, to the best of my research, no reference to either of these facets prior to 1996 when it comes to the acts. The 1940 Act is silent on any aspect of confidentiality or transparency. And it is only in the 1996 enactment, and that too in the context of conciliation, that we have Section 75 that deals with confidentiality. The section provided that the conciliator and all parties shall keep confidential all matters relating to conciliation. The confidentiality was also to extend to the settlement agreement, except where its disclosure was necessary for purposes of implementation and enforcement. I've quoted the section so that we are clear on what the language used was. Now, with the passage of time, there was a need for increased transparency. And the Justice B.N. Sri Krishna committee that was constituted looked into various aspects of arbitration and the arbitral process in an attempt to make the process more robust. One of the aspects they touched on was confidentiality and transparency. Now, I want to set in context the recommendation that the committee ultimately made. They looked into the aspect that the Act does not contain any provision expressly providing for confidentiality, and in the absence of such a provision, the parties necessarily have to fall back upon whatever is provided in the agreement. Sometimes the agreement is also silent, in which case they have to fall back on the rules of the institution that will govern the process. They then went on to examine the cleavage of opinion in various jurisdictions in regard to confidentiality and the amount of transparency that was required. And ultimately, the recommendation that they made was this: a new provision may be inserted in Part 1 of the Act, providing for confidentiality of arbitral proceedings unless disclosure is required by legal duty, to protect or enforce a legal right, or to enforce or challenge an award before a court or a judicial authority. So there are 4 key ingredients in this. Nothing in regard to the parties bound by the confidentiality provision, and they envisaged 3 situations, 3 specific situations where there may be an exception to the provision. Now, this recommendation was accepted only partly, and the provision that was introduced, Section 42A, that was introduced in 2019 by the Arbitration and Conciliation Amendment Act, is couched in narrower language. Now, this provided that the arbitrator, the arbitral institution, and the parties to the arbitration agreement shall maintain confidentiality of all arbitral proceedings except award where its disclosure is necessary for the purpose of implementation and enforcement of award. So we find that this is modeled along the lines of Section 75, and the ingredients that have been referred to by the committee do not find place in the provision as we have it today. Now, the chairperson was also mentioning this aspect of it. The ingredients would be the non-obstante clause that we have, which deprives the party of their autonomy completely when it comes to matters in respect of which and to what extent confidentiality is to be maintained. And the limited exception which is provided is in the context of implementation and enforcement alone. Now, disclosure of proceedings may be required for various situations contemplated under the Act when it comes to a challenge to the award itself, or interim measures under Section 9, or for extension of time under Section 29A, or an appeal under 37. None of these find place in the provision. So one of the questions that would arise is whether Section 42A were mandatory or directory. And also the rigor of Section 42A is only qua the arbitrator, the arbitral institutions, and the parties to the agreement. However, there are many persons who would be privy to the proceedings itself, like the counsel or the secretarial staff or transcribers, various other people who would be party to the proceedings who are not bound by the rigor of these proceedings. Now, I will be circumspect about proceeding further in this for obvious reasons, and we'll leave that at that as some of the possible questions that might arise for consideration going down. Now, some of the express duties of confidentiality will be protection of sensitive information, including information relating to proprietary information or information relating to intellectual properties, the reputation of the parties, or protection from probable claims that are similar to the subject matter of the arbitration itself. Now, this was sought to be corrected by the insertion of Sections 43I and J in 2019 that provide for grading of arbitral institutions and setting up of norms for accreditation of the arbitrators. This would greatly aid in selection of arbitrators by parties, because as of now, it's a blind spot. One has no idea what the compunctions of the arbitrators would be, how they would address the arbitration process. So this was one aspect that was attempted to be looked into. Section 43K provides for the maintenance of a central registry of awards made in India as well as other records. Now, there is a possibility that ultimately the registry could maintain redacted awards. However, this again remains in the realm of speculation because these provisions are yet to be notified. We have learned from what Kevin said about the experience that Singapore has with respect to similar provisions. But as far as India is concerned, till such time the provisions are notified, rules come into place, and they kick in to action, we will really never know the impact that these provisions have. So time will have to tell. Now, that's as far as legislative history goes, and the provisions as we have them today. I'm sorry, there was some overlap with what was referred to by the chairperson, but you must allow me that, seeing as the subject matter was one and the same. The second part of my presentation deals with the interplay between confidentiality and transparency in the context of public and private interests. Now, times today are such that we find business interests crossing national borders, and it is thus that some kinds of arbitration are found to require greater degrees of transparency than some others do. So I would like to again proceed on an academic line and place this in historical context. Transparency under the investor-state dispute settlement resolution scheme is traced to the late 1990s in the context of arbitrations that were conducted under the North American Free Trade Agreement, that is NAFTA. In 2001, the member states came to a conclusion that one should do away with absolute confidentiality and perhaps relax the rigor of confidentiality to some extent and bring in some transparency in the process. This was the start of several international measures to bring in transparency. In 2014, the UNCITRAL adopted the transparency rules. In 2017, the United Nations Convention on Transparency in Treaty-Based Investor-State Arbitration came into force. Now, this provided for a mechanism where ratifying states could apply the 2017 rules even if the initiation of the arbitral proceedings had been prior to 2014, and this was called the Mauritius Convention. Now, the second set of rules that would apply to these investor treaties would be the ICSID rules, which are the International Center for Settlement of Investor Dispute Rules. These rules were amended periodically from 2006, and the most recent version we have of them is in 2022. Kevin was also mentioning these. They provide for public access to documents, publication of awards, public attendance at hearings, and attendance by the amicus curiae or the non-participating person. The caveat to their application is threefold. One is the parties should have agreed otherwise. Second is other applicable rules, conventions, or treaties should apply. And thirdly, the Mauritius Convention would apply. Therefore, the general understanding appears to be all around that the landscape as far as dispute settlement in investor-state dispute settlement is concerned is moving towards greater and more enhanced transparency. That's all for the better, since statistics show that the number of such disputes is on the rise. In 2020, we had 58 such disputes before the ICSID and 66 in 2021. So the need for transparency is perhaps well conceived. There are some interesting articles online if you are interested in reading up on this. As the chairman said, today we don't have Indian law. None of the Indian enactments give us a workable definition of what is transparency in this context. And I found an interesting definition in a publication by Chase and Mitchell. It said, transparency in the context of international investment treaty arbitration would revolve around the 4 A's: the adequacy, accuracy, availability, and accessibility of knowledge and information about policies and activities of the international investment law regime and its participants, of the central organizations functioning within it on matters relevant to compliance and effectiveness, and about the operation of the norms, rules, and procedures underlying this regime. Now, in an interesting article entitled Transparency in International Investment Law, the Good, the Bad, and the Murky, the author says that transparency is the buzzword du jour within international investment law. And very poetically, she says, and I quote, "Oft invoked and seldom defined, it slides like butter on toast across the debates saturating nearly every facet of the international legal regime governing foreign direct investment." That's something to think about and mull over. So we have taken today a stand that increasingly there should be an emphasis and a distinction made between transparency in private commercial arbitration and transparency in investment treaty arbitration. Now, I saw that there was a practical exposure that India had in this regard. We had made such a distinction, albeit unsuccessfully, before the Singapore courts in the context of the Vedanta arbitration. And this was an arbitration that had its genesis in the 2012 amendment to the Income Tax Act 1961, a direct tax amendment. And we had opted to go before the Singapore courts, both in the context of Vedanta Resources as well as in the context of Cain Energy. And in the case of Cain, we had suffered some damages that had been imposed, including costs. Now, India had made a distinction in the context of Singapore's position, fairly rigid position on confidentiality. And there is a very interesting quote that I would like to make from the judgment of the Singapore Supreme Court with regard to the distinction that India had made. Now, the existing law in Singapore imposes a general obligation on confidentiality regards arbitration. And the Indian government moved the High Court seeking a declaration that documents generated in the Vedanta arbitration would not be confidential or private. This is the issue that was crystallized by the courts. In this context, this is what the Singapore courts held. And I quote, Singapore's common law of arbitration imposes a general obligation of confidentiality on arbitration in Singapore generally, without drawing any distinction between private arbitration and investment treaty arbitration. But it is certainly true that the considerations which apply to a private arbitration do not apply with equal force to investment treaty arbitrations. The latter raise important issues of public interest and public policy involving a sovereign which is ultimately accountable to its public and its people. A different approach may well be warranted in investment treaty arbitration, given the different stakeholders and the sovereign and public interests implicated. So the claim of India was not accepted, though they did defer to the distinction that we sought to make. We find that the defense of the state normally in matters where information is sought is that it is confidential and it is protected by state secret privilege. Invariably, we invoke the provisions of the Right to Information Act 2005, specifically Section 8 and Section 24. And there was one article where the information seeker was lamenting that there must be some uniformity when this issue is addressed. While sovereign republics all over the world do ask for increased transparency in investment treaty matters, when it comes to domestic issues, we find a reluctance that the state has in handing over these documents. So perhaps it's time that we think of formalizing what would be an acceptable standard of transparency when it comes to private investment treaties. In fact, yesterday there were some very interesting sessions on party autonomy, and both chaired by Justice Sikri and Justice Indu Malhotra. And those sessions revealed that while party autonomy was paramount, some inroads are being made in the context of investment treaties. And you would all be aware of the White Industries case, where there had been a significant award against India, with interest and with costs. The question that will arise is, who is going to meet these costs? These costs are all to be, we don't have a fund for such costs. So who is going to meet these costs? So ultimately, if it is the public which has to bear the brunt of these costs, then might it be prudent to allow for public participation so that there is not just participation but awareness, and also the public are kept informed about what is happening, since it may ultimately have an impact on their pocket. So I will conclude with this. I had started by saying that arbitration is a private and an alternate method of dispute resolution. Perhaps today we may think about this. It is not an alternate, but may be considered by some as a parallel mode of dispute resolution. And far from being private, I think it is also becoming, and secret, as Kevin said, there may also be some reasons to believe that the blurring of lines between confidentiality and transparency has begun. Thank you very much.
Thank you. Now I request Dr. Birendra Saraf, the Advocate General of Maharashtra, Mumbai, to sort of make his presentation.
After all the speakers have shared both their experience and knowledge, I'll do what I feel I'm best at, that is to raise issues on the existing provisions and point out the difficulties in its implementation. The Arbitration Act in India has been a legislation which has been a subject matter of immense litigation. I've seen very few legislations in India which within a short time has had so much of judicial scrutiny, right up to 7-judge benches of the Supreme Court, a commercial legislation being subjected to so much of judicial scrutiny. And the reason partly for that was that either we adopted a foreign model blindly into India without realizing our own ground realities, or else we failed to learn from the experience of other jurisdictions. And in relation to confidentiality, I believe it is the second which is applicable. We had originally, as the earlier speakers pointed out, Section 75, which was in relation to conciliation proceedings. Now, the requirement of confidentiality in conciliation is very different, because there you divulge a lot of things which you would otherwise not in a kind of contested matter. But while introducing a provision for confidentiality in arbitration, we blindly adopted the same provision and introduced it into the arbitration proceedings. And a provision which is Section 42A, which surprisingly is not even derogable, as against many other provisions in the Arbitration Act which say, unless the parties otherwise agree. This provision doesn't even provide for such a right of derogation between the parties. And in fact, it starts with a non-obstanted clause, as the earlier speakers pointed out, notwithstanding anything contained by any other law for the time being enforced, which would include even something like an RTI or any other law which requires a disclosure. Plus, the requirement of maintaining confidentiality is cast on only the arbitrator, the parties, and the arbitral institution. What about the witnesses who come to give evidence? What about many other stakeholders who are party to the arbitration? And lastly, the exception which is given to the obligation of confidentiality is only one. That is for the purpose of implementation and enforcement of the award. There is no other exception which is given to this requirement to maintain confidentiality. Now, seeing what is happening in most other jurisdictions, most of the other jurisdictions do not have such a statutory requirement of confidentiality, and they leave it to the parties to determine confidentiality. In England, there was no such provision, and by a judgment in the case of Ali Shipping, the English courts implied a term of confidentiality in an arbitration clause. So the courts, English courts, taking the principle of an official bystander, said that there is an implicit clause to maintain confidentiality in a arbitration proceedings. But that very court laid down various situations in which a disclosure may be required, and that included by the consent of parties, by an order of the court, by the leave of the court obtained, public interest, or the interest of justice. These were various exceptions which the English court itself carved out, where a party will not be restrained by an obligation of confidentiality to make a disclosure. Now, this has been the practice which has been followed in England as a result of a judgment of the English court. So far as Australia is concerned, they had two different legislations, one governing the domestic arbitration, one governing the international arbitration. And in 1984, there was a judgment of an Australian court in the case of SOS Australia, which said that there is no implied term of confidentiality, that what is private need not always be confidential. So merely because an arbitration is conducted in a private manner, that doesn't mean everything about it is confidential. The Australian legislature thereafter amended its act and included provisions regarding confidentiality. But both the legislations had detailed provisions in circumstances in which disclosure can be made. They had provisions setting out in what situations the parties themselves can make a disclosure, in what circumstances the court may require a disclosure, in what circumstances the court may prohibit a disclosure, and various other detailed provisions were made. Similarly, there was also an opt-out provision where in case of domestic arbitrations, the parties could opt out of maintaining confidentiality. So these are the extensive provisions which were included in the Australian code. Similar provisions were there in the New Zealand legislation and also in the Hong Kong legislation. Some of the legislations even provided of conduct of proceedings in court in a private manner, that a request could be made to the court that proceedings arising out of the arbitration should be conducted in court in a private manner, that is in camera as we call it, so that the confidentiality is not breached. Those provisions are also available. Now what we have today is just a blanket provision without considering any of these circumstances which were with us. We could have seen the legislations of various other countries, the experience of various other countries and adopted from them. But we didn't do that. Now the situation today is there could be so many situations in India where such a disclosure would be required. A first situation could be where one of the parties to the arbitration requires to disclose the arbitral proceedings to assert or establish its own rights against a third party. Let me give you an example. Suppose a party has taken an insurance which requires that before a debt recovery insurance, that if somebody defaults in payment of money, I shall pay you the money. But that has an obligation that before coming to us, you must make genuine attempts to recover the money from the defaulting party. And you go into an arbitration and you pursue that party and you fail. Now, in those circumstances, the insurance company could want to see your arbitration proceedings before they give you an insurance claim or they consider your insurance claim. So this will be a claim of a party to the arbitration where it requires such a disclosure to assert its rights against any third parties. All other laws, all other legislations which provide for confidentiality have provided for this exception. But under our statute as it stands today, there is no such power given to the party to disclose. Then there could be a situation where a third party's right is affected by an arbitration conducted between two parties. We have had many situations where the courts have held that though a third party cannot challenge an award between two parties, it can file a suit to set aside that award if his rights are affected in some manner, if his property is affected by the arbitration award. Now, if that third party comes with a case that there has been a collusion between the arbitrating parties to defeat his right, can such a third party be denied altogether the disclosure of documents in relation to that arbitration? So there could be situations where third party rights are affected. Then there could be so many situations where there are statutory requirements under regulatory laws. Then you are obliged to give it to them. But this says notwithstanding any law for the time being in force. So that's again a situation where such a disclosure may be required in law, but the Arbitration Act, by putting a non-obstanted clause, may in fact affect the rights of that third party, statutory authority from enforcing its rights under that other statute. There could be situations where public interest is involved. Public interest could be in so many situations. Suppose there is an action by a state against a private citizen about, say, a huge plot of land. I'm just giving you a very simple example. We could have so many complex situations where the state is a party to an arbitration, which it had given on lease to a party. That party terminated the statutory authority, they wasn't taking action, and faced with a PIL, it was sent to arbitration. Now there, the state authority did not conduct the arbitration properly. in a manner, it was conducted in a manner which helped the private party. Now, is it a situation where that arbitration proceeding, the manner in which it was conducted, should not be made available to any citizen or any person who has an interest in that property? So there are many situations in which public interest would require the disclosure of certain arbitral proceedings. That is the essence of the RTI Act, in fact, that you could ask for any proceedings filed in court, any proceeding affidavit filed by a government authority in court, to know what stand the government has taken, but not so in arbitration proceedings. So that's another situation where it is required. Thirdly, the courts have carved out an interest of justice. Now, what if a same person has come to give evidence in court and there is reliable material to show that in a private arbitration he had given absolutely contradictory evidence on the same subject matter? Now, can't that evidence of that very person in the arbitration be required to be called for to analyze how truthful this witness is being? So those are many situations where, to maintain the sanctity of the court in the interest of justice, such a disclosure of certain part of arbitration proceedings are to be considered. And these are all aspects which have been considered in different statutes, in different judgments of English courts, of Australian courts, where they have dealt with these issues. They have differentiated between public interest and the interest of justice. And there has been detailed discussions on these aspects. But our legislation has given no such scope for an exception. Now, these are situations where 42A itself has problems and which needs to be met sooner than later. Otherwise, it will be left to the courts to once again interpret these provisions and to read into these provisions various exceptions and situations. After the award is passed, there could be many situations, or even pending the proceedings. Suppose there is a Section 9 proceeding filed by a party to an arbitration seeking interim relief. Now, it is settled law in India that in certain circumstances you can seek relief even against a third party in a Section 9 proceeding. Now, you implead a third party in a Section 9 proceeding for interim relief, and in those proceedings, you are compelled to disclose some part of admissions made by witnesses by the other side in the arbitration, or you have to produce certain documents which are a party to the, which are placed before the arbitrator. Now, wouldn't that third party, who is a party to the arbitration Section 9 proceeding, be aware of all, come to know of all this? Will that be a breach of confidentiality? We had this situation arising in one of our matters in Bombay High Court, where the respondent came and said that by impleading a third party, you have breached confidentiality. Of course, we didn't lead to a situation of ruling in that, but that's a situation which is where 42A becomes difficult to implement. Again, a challenge proceeding where the arbitral award is challenged. Now, every day we see that how much ever our 34 says that there should be no reappreciation of evidence, there should be no requirement of only a patent illegality of law, but sometimes even to assess that, the entirety of the record before the arbitrator becomes necessary. And once you produce that, it becomes a part of a court record, and it gets governed by the court rules, where in certain situations third parties are entitled to take inspection of the court records as per each high court's rules. Now, how do we maintain the confidentiality of the arbitration proceedings in those situations? So as I said, these are various practical difficulties in implementing these provisions. Either this provision needs to be modified, or else we'll have very soon judgments reading these provisions, reading conditions into it, and that will only lead to further litigation. But this provision as it stands today, I find practically very difficult to implement in its entirety. And I leave you all with these thoughts. As I said, my job is to leave you all with thoughts today. I don't have a solution to everything that the learned judges here will find someday or the other soon. And I think once we have your questions, then maybe we'll be in a better position to discuss this. Thank you.
Thank you, Dr. Saraf. We just How much time, if I may just ask Justice Palli? Okay, we have time. Very well. Kevin, I give you 2 minutes to sort of reflect on what has been spoken, and then I'll ask Sumita, and then Viren, and then we'll have some questions from the audience. I mean, who is the youngest here? Can anybody think? Not Jaishankar Nambian. See, there are a lot of claimants to being the youngest. I mean, that's the interesting part here. Everybody wants to be young. And just check up. We'll take question from the youngest here. And we'll take question from a senior lawyer. We'll take a question from a judge. And like that. So at least 3 questions are guaranteed. So, Kevin.
Thanks, Judge. I got a lot of benefit from the interventions, and I think what is difficult is how you go about rule drafting and you take into account all of these different considerations, commercial parties, states, all of which we have at SIAC. And well, benefiting from the interventions, what I was telling myself is that it must be correct if you go in favor of party autonomy. So if the parties are able to agree to a bespoke confidentiality clause, if they've agreed to the institutional rules that provide for a certain level of confidentiality, because whether it's in New Delhi or Singapore, you can have any number of administering institutions. So you can look at the different provisions in the institutions, and if you decide that you want very strong provisions on confidentiality, which exist under the SIAC rules, then you can choose SIAC. So, and then also with a seat, if you want to have a seat where it's codified, say in Hong Kong or New Zealand, then you can choose that seat of arbitration. So I think that that must be correct. I also think the distinction between transparency within the proceedings and public transparency is an important one. And I think that institutions have done very well on being more transparent within the proceedings. I think ICC is a great example of this, whereby the parties, and now a single party, can request for the reasoning of the ICC court. SIAC is taking great steps there as well, because it used to be that there was this opaque wall, so institutional decisions were being made, sometimes with reasons not being provided. And quite, well, in this regard, most institutional rules will say we don't have to provide decisions, but we probably should provide decisions, and institutions are doing that more. So I think that that is the way that I look at it. I think we are likely going to include those provisions, but it's almost like a 2-stage test, and there's a safety valve. So you first decide on the SIAC rules 2023, which says that the SIAC may publish anonymized decisions of awards. We will thereafter give parties multiple opportunities to opt out, not both parties, but a single party. So you get to exercise your party autonomy through the choice of institutional rules, and then we are going to give you an additional opportunity thereafter. So that will make the right kind of cases. In cases where the parties are okay with it, these are the ones that are going to then be published, and then will advance arbitration scholarship and arbitration and show the kind of awards that are being drafted in Asia.
Thank you, Kevin. Now, Anita would just put in her 2 minutes. Before that, I rectified a bit of a discrimination going on. I saw chocolates on every table barring this one. So I arranged for it to be brought over. Thank you.
Having had the benefit of the earlier speakers, I would still maintain that we should provide for some sort of a framework to understand the manner in which we understand confidentiality and transparency. I think Singapore has made its stand very clear, and India has, by the introduction of the provisions that we have now, also made their stands on this position very clear. The topic is the great debate between confidentiality and transparency, and I would think that we cannot resolve it at this table. The debate has to continue. And as was said, it is for ultimately questions to be raised and for the courts to deliberate on those questions and arrive at possible resolutions to those questions. In the interregnum, what I would suggest is that in the introductory remarks that had been made by Kevin, he had referred to several deliberations, several rounds of deliberations and discussions that the SIAC had made in the context of enhancing transparency by publication of awards. Whether you publish redacted awards how comfortable parties and arbitrators, how comfortable institutions are in that context. Perhaps if those could be made available on a public domain, other states, other institutions could have the benefit of those deliberations, and that may help us or assist in arriving at our own understanding of what confidentiality, what degree of confidentiality and transparency we want to build into our processes. That's all I have to say. Thank you.
Thank you, Justice Suman. Now, Biren, your 2 minutes.
Hearing everyone, I really believe that the safest course of action in a situation will be to leave it to the parties whether they would like to maintain confidentiality, and if so, on what aspects and what would be the exceptions to the confidentiality clause. What we could do possibly is to frame a model confidentiality clause considering of different nature of contracts and leave it to the parties either to adopt that with variations, without variations, in its entirety, or maybe parts of it. That could give a guideline of confidentiality and various circumstances in which it could be waived. And leave it to the parties then to consider the nature of their contracts, the nature of their arbitrations, nature of their statutory obligations, and then decide what part of the confidentiality obligations to agree upon. That might be a more practical solution rather than having a blanket clause to cover everything. So that's what I feel in the long run might be a more viable option.
Thank you, Biren. We have also formulated one more additional category besides the 3 that I spoke about. This is, those who are Indians here, they will know it's the quick gun Murugan category. Now, quick gun Murugan, the first one to raise the hand was Justice Jaishankar Nambiar. So, first question to be addressed by Jaishankar Nambiar.
Sorry, I thought I lifted my hand for the question as to who was the youngest. I wasn't actually volunteering to ask a question, but now that I've settled with this, I'd ask it. It was interesting to hear, well, I missed out on Kevin's speech, but then I think the other 2 I managed to hear. But Dr. Saraf, you were talking about the, the limitations of the clause that we now have, which ensure a confidentiality in arbitral proceedings. Wouldn't that be because of the conceptual difference between litigation as we know it in courts and arbitration? Because litigation is basically, we've grown up on the principle of public interest immunity being a cause for non-disclosure.
Right.
As against transparency in general, but exception is public interest immunity. In arbitration, which is conceptually different from litigation, we are talking about party autonomy, we are talking about a very private kind of litigation. Public interest is not the main object there.
Right.
So wouldn't confidentiality be the rule rather than the exception?
I'm not at all against confidentiality being a rule, but starting with party autonomy, when we talk about party autonomy, that's what I mean, that leave it to the parties to decide whether this is the nature of arbitration which requires confidentiality, and if it requires confidentiality, in what circumstances either party can disclose that information. So it's no point trusting such a pre-drafted clause on the parties. And as I said, this clause doesn't even leave the parties the option to derogate from it. There are so many provisions in the Arbitration Act. We start with the word unless the parties otherwise agree. 42A doesn't even give that option to the parties. So that's where my problem lies. So you are having a pre-drafted confidentiality clause and thrusting it on the parties. That is in fact affecting party autonomy. But what I propose to say is that we should respect party autonomy, give them a choice, give them a guidance, and then leave it to them whether they would want to adopt it or not. So the party autonomy is in no manner affected by not making such a clause mandatory.
Thank you, Biren. We'll take a question just after you. We'll take a question from a lady. So somebody should raise the hand, and the next question will be from a lady. Yes, there you are. And yes, you may address first. Yes, please. After that, you. Yes, please go ahead. You in the white jacket.
I think there's an equivalent compelling state interest also other than the party autonomy to ensure rule of law in arbitration proceedings. Because the agreement is given statutory status, and then the state is authorized to commit violence in form of execution of those awards. So to that extent, there's a compelling state interest because of which transparency must be the rule and confidentiality should be the exception. Another benefit of such a transparent regime would be that it would be a check on the actions of arbitrators also. Just like judges are often tested by the judgments they write, which are published and are in public domain. Similarly, arbitrators will also be regulated, can be regulated, if their awards were to be published, of course with exceptions of redaction, etc., so on and so forth. So just your thoughts on that.
Give your name, please.
My name is Pallav Mongia. I'm an advocate on record. Yeah.
Mr. Mongia, would Biren, because this was a supplementary, so I would request Biren to take it.
In fact, in a particular manner, I quite agree with you because the disclosure of various information regarding arbitration may be necessary in various other provisions of the Arbitration Act. One of the issues which may arise is, say, a party has justifiable reasons to believe that the arbitrator is not impartial. He wants to challenge the authority of the arbitrator on various issues, including that he has been appointed by the same party in earlier arbitrations. He has consistently given awards in their favor, whatever way. There are certain information which a party requires in that regard. The lack of transparency will deprive him of this situation. There could be another side where now an arbitrator is to be made a party to certain proceedings. If you allege that an arbitrator is disqualified or that he is impartial, impartial, the arbitrator may have to defend himself. And for that, he may be required to disclose certain past proceedings to justify that he has never been impartial. So there could be very many situations where under the Arbitration Act itself, in section 14 proceedings or many other proceedings, these are kind of disclosures may be required. So those exceptions need to be either read into this provision or we need to have express exceptions to these provisions in that regard. To that extent, I surely agree that there is a requirement of disclosure for both the benefit of the parties and the arbitrators also.
To supplement this a bit.
Just to say that your thoughts are well-founded and that confidentiality will definitely have a good effect in several areas, including understanding the arbitrator better and also drawing whatever judicial precedential value one could from the awards, whether redacted or not. Again, to clarify that the autonomy of the state, if it is a party to an arbitration, is definitely, to the extent to which it is bound to be protected, has to be protected. No doubt about that. We are only here talking about different thresholds of transparency to be fixed. Completely private arbitration, where both the parties are private, and one where the state may also have a role to play.
Yes, young lady there, yes.
Thank you so much, sir, for allowing me to asking the question.
Please introduce yourself first.
Yeah, my name is Anjali Chawla and I'm the assistant professor at Jindal Global Law School. My question is about the publication of redacted awards. As Kevin mentioned that now the publication of redacted award happens with the consent of the parties. I don't find any parameters in the SIAC rule, so I want to ask you this question. That you said with the consent of the parties you can redact the award and publish it. So how much control does the parties have on such redaction? And if there is a lot of control that is given to the parties, can there be a situation that after redacting the essential part of the award loses its relevancy and then there is no point of publishing it, because ultimately the idea of publishing award is to create a jurisprudence?
I will ask Kevin to answer this, and the next question we'll take it from a man who is wearing a white shirt and a tie. All right? I have identified the man, and Kevin will answer the question. Thanks
very much. Certainly no lack of lettered questions in India. It's tricky because, so under the SIAC rules 2016, the parties have ultimate authority because you need express consent, and you need that consent in the throes of an adversarial process. I think that that's why the better approach is to have the consent incorporated in the rules and then allow a party to opt out. I think whether or not you would put the redaction to the parties, I think that's an interesting question and one that we've discussed internally. I may be somewhat cynical in terms of arbitration, and I would say that would become a trial after the trial or a trial within the trial if both parties then had to agree on the redaction. And I should say further to the previous question, one thing that we have to be mindful about, and that's why the approach has to be quite careful and commercial, is that we could import some qualities of investment arbitration into commercial arbitration with publication. And now you have challenges being based on issues decided by previous tribunals. Issue conflict is starting to become a bit more seen in commercial arbitration. So we want to make sure as an arbitration bar that we do this thoughtfully. And I suppose that I would reiterate my previous point that if you follow the consent of the parties, if you follow party autonomy, it must be correct.
Thank you, Kevin. Yes, please introduce yourself and then.
Thank you. My name is Jean-Rémy Demestre. I am the CEO and co-founder of Hon'ble, which is a search engine for arbitration. So thanks a lot for the debate. It's a debate that we are having within our company for the past 5 years because one of our key jobs is actually to collect and publish arbitral awards. And I thought that I could bring a few information also to this debate. And first, you know, we are discussing the publication of awards that are unredacted because they are becoming public through enforcement proceedings. 5 years ago, it was less than 1% of commercial arbitration awards that were made public through this way. Now, it's almost 20% of the commercial arbitration award that become public because one party is enforcing them or setting aside this award in a jurisdiction in which we have to publish the award. So in terms of quantity, it makes a big difference, but it's maybe not the best awards that are becoming public. That's why also institutions are taking this step to publish more awards, and now we are partnering with more than 15 arbitral centers to help them to publish the award. And each of them is taking a different direction because it's complicated and no one really has a perfect answer how to do it. ICC, for instance, they decided to have an opt-out, so parties have control if there is publication or not, and they have to not oppose. But I can give some other examples. For instance, AAA ICDR in the US or the Russian Arbitration Center, they decided to take control on the publication, and if they consider that the redaction is enough, they will publish. And they are publishing a lot of awards like that. But of course, what is the level of redaction is very complicated. For instance, AAA, they decided to have a body of independent practitioners that are reviewing the redacted award, and they try to identify the parties. And if they can't, the award will be published. So it's very different. In Brazil, because you've been discussing awards against public entities, in Brazil, you know, probably they have a law that oblige to publish all awards involving a public entity, and so all arbitral centers, they have to go through this publication. So it's a very complicated topic. I'm glad to have your views on this. I'm sorry, it was not really a question.
Thank you. Actually, you have shared your experience. It's not a question, but it's a statement. Absolutely. So I take it like that. Exactly. We are not having any answer. Somebody who just this thing, we'll just take a 30-second question and a 30-second response, and after that we close this because the next session is to start. The people are anxious. No, there is somebody who I'd already identified. Yes.
My understanding is that the debate really has nothing to do with the efficient and proper conduct of arbitration. It's really a debate that countries and institutions are having, whether or not they want to attract arbitration or to be an arbitration destination or institution of choice. The other thing is just to point out that to Justice Sumanth, since she cited India's advocacy for transparency before the Singapore court, once India lost the Ken Award, they sang a very different song on transparency in the Vedanta arbitration. We can't disclose more than that because we represented Vedanta in that arbitration. So parties' interests change from time to time, or views change from time to time on transparency and disclosure.
That's a very difficult question for a judge to answer. I would advise Justice Suman not to say anything. And we conclude this program. I think it has been a program of some use, and I'm sure we are left with some serious thoughts on confidentiality and transparency battle. Yes, we'll conclude.
Thank you. With Justice Roy's remarks, that brings us to the end of a very enriching session, a session which I must say is being live transcribed, so there's no secrecy or confidentiality about it. I thank every panelist for gracing us with their presence, and we conclude the session. Thank you. Thank you, everyone. The next session will begin in the next 10 minutes, so please reconvene at 12 o'clock. Thank you.